Welcome back, Novello Nation, to another episode of the Aaron Novello podcast. We have with us an absolute rock star, awesome human being, somebody we refer on a regular basis to all of our clients who need her specific expertise. Her name is Danielle Greenberg, and she knows probate inside and out. I really appreciate you taking the time to be with us here today.
Thanks, Aaron. Happy to help.
Yeah, absolutely. So, I think what's interesting is that I find in everyday conversations with homeowners that, being that we live in Florida, I tease people that we live in heaven's waiting room, right? So this issue of probate comes up on a regular basis, and it's something that a lot of people really don't understand. So I wanted to invite you on the platform to really, share your knowledge so that way, it could be helpful or useful to people in some way. So if you could, briefly kind of share with people what actually is probate, because I don't think people generally understand that.
Right. Okay. So basically, when you die, if you have any assets that are in your individual name that don't have a beneficiary on them. So if you have a bank account, or if you own real estate, or if you have a 401k or different assets, and you've failed to designate a beneficiary on them or move them into a trust or other different titling things, when you pass away, the only way for those assets to be transferred on to whoever you're leaving them to is through a process called probate. So people often get confused if you have a will or if you don't have a will. Either way, the court is in charge of this probate process. If you have a will, we call it testate. If you don't have a will, it's called intestate. If you have a will, you can leave your property in most instances to whomever you like. There's some exceptions with cutting your spouse out. They're entitled to get about 30% of your estate, or if you have minor children, with your homestead property. And otherwise, if you don't have a will, then the law controls. And a lot of times people are very unhappy with the outcome, not realizing that the daughter that your father had that he never spoke to is getting her share, that your stepmom is getting probably 50% of the estate, et cetera. So the only way to override the baseline rules of law is to create a will. And without a will, it just goes according to a very specific flow.
Had a conversation. I was sitting at a table with someone, and she pulled out a will and was super excited about it. And the moment she pulled it out, it was like handwritten. So initially it's a red flag. And then number two, I got you on the phone and you were cool enough to answer at like 6 o'clock. And I'm like, yeah, here's the will. You're like, okay, cool. You're like, how many witnesses? And I was like, one. And you're like, state of Florida says you need two. So that's invalid.
And the two witnesses have to be in the room with each other and the signer at the same time. I had an attorney get a will thrown out because all he did was track down the witnesses, and they said, oh, no, we weren't together. I signed it this day. The person signed, and then the will was invalid. So,
yeah. And it was interesting because as I'm sitting there, she's like, well, I was in the room, so I could just sign it now. I'm like, that's a felony. You should not do that. That's against the law. Right. So then talk a little bit about, too, as it pertains to real property specifically. I think oftentimes people get confused too with regards to homestead versus like secondary homes. And what I find, which is so interesting, Danielle, because I find that attorneys oftentimes, if they're not like you and they don't do it all the time and really understand it in and out, they don't understand it. So talk a little bit about how that works and how technically in the state of Florida, if a homesteaded property is passing to linear heirs, it technically passes outside of probate. So talk a little bit about that.
Yes. So Florida is probably has one of the highest homestead protections for real property, I think, of almost any state. So it doesn't matter how much the property costs. If it's where you reside and you own, and your name's on it, you get homestead protection. People often get confused with, I got homestead for tax purposes or something else, which doesn't have to do with homestead for probate purposes, which is confusing. So basically, even if you don't, for example, apply for the homestead tax exemption on your property that Florida allows, that doesn't keep the property from being determined as your homestead. So if you own it or own a fraction of it and you reside there, it's considered your homestead in Florida.
And this is cool because like I'm learning as we're having this conversation, even if it's not in a life estate, which I know that's a way of holding title, If it's just I own it and then I legally get married to, let's say, a second person, and we don't do a prenup and we don't have any particular documents in the state of Florida, that second, like that spouse has the homestead rights and they're entitled to the asset. Is that right?
Correct.
Wow, sometimes that makes a lot of people angry, I imagine.
Yes. I was just going to say, sometimes there could be an exception. Like if you owned the property with like your sister, joint tenants with right of survivorship, and then you got married after, that first deed, the joint tenants with right of survivorship that you had with your sister would supersede or override the marriage because that was in place first. And since we're talking about it, that's also something that people get really confused about. I'll just set this straight. So basically there's 3 ways you can own property with somebody else. You can own it tenants in common. So if you go on the property appraiser website and you look at a deed and it says to, so person A and person B, and that's all it says, like just to Jessica and Michael, and they're not married in this scenario. When Jessica dies, 50% belongs to Jessica's estate. When Michael dies, 50% belongs to his estate. Florida is very clear that if you want the full share to pass to the other person on death, you must use the words joint tenants with right of survivorship. So if you look up a deed and it says to Jessica and Michael, joint tenants with right of survivorship, then whomever dies first, the property will pass to the survivor of the 2 of them. Absent that exact expression, joint tenants with right of survivorship is going 50% to one person's estate or one person, 50% to the other. The exception to that is if you're married. You don't have to say joint tenants with right of survivorship. If you buy the property together as a married couple, then you will get that joint tenants, which basically means the property will transfer automatically to the survivor of the 2 of you upon death if you're married. And I would just add that if you're married and you get divorced and you don't fix the title to the property, then that would sort of sever that, and 50% would go to the wife and 50% would go to the husband.
Let's say someone finds themselves in a situation where a family member passes and maybe they don't live in a geographic area, which is oftentimes the case in Florida, and they don't know if the person had a will or not. Like they don't, because I find that that's frequently a dynamic. So walk us through, like if you were going to give a blueprint for kind of, beneficiaries, what would be like step 1, step 2, step 3 that you would propose that they start to do to help them to kind of get a handle on the situation?
Obviously, for me, the first step, if they own real property, I always immediately go on the property appraiser website and look up the deed to see how it's titled, to see if they're correct about how they think the person owned it, because that's fundamental. One of the best things I tell people when they're in my office is please go make sure all of your assets have beneficiaries on them, and make sure that the beneficiaries aren't under the age of 18.
If somebody finds themselves where, somebody passed and stuff, it's like, all right, number 1, how did they hold title? Number 2, are they payable upon death, or are there beneficiaries for the assets? Number 3, I wrote down, is there a will? And if not, or if so, do you have a copy? And do you know the attorney who drafted it?
So a very common scenario I see is there are 5 children. The parent passes away. One of the children has moved into the property and just decided it's theirs or doesn't want to sell.
Happens all the time.
All the time. So basically what happens in that scenario is I can do the probate for the family and move the title to the 5 surviving children. That's a preliminary step that has to take place. But once I finish that process and you want to sell the property, normally, obviously, the best scenario is to get cooperation and all 5 of you agree and you sell it. But if one person is a holdout or 2 or whatever, you can even own 3% of the property. You can file an action, you need an attorney, called a partition action where you force the sale of the property.
For anybody who's listening or watching this, if you're thinking like, hey, I think I could just figure this out on myself, like going online and stuff, no. You should definitely reach out to a professional like Danielle. She's an absolute rock star. So if anybody has any questions, like if they need your help, where can they find you?
So my office is in Fort Lauderdale. I have a website, DanielleGreenbergLaw.com. Greenberg is B-E-R-G. You know, we can set up an appointment. A lot of people ask me, like, if we're going to do estate planning, what do they need to bring in? It's normally nothing, because what I really need from you is information. I mean, it's helpful to know if you're going to designate a power of attorney. I need normally that person's name and address and phone number. But as far as your assets go, you know, I don't necessarily need to see them. I just need to know where they are so I can keep notes. And a lot of times when people come to see me, it's kind of like going to your yearly visit at the doctor or something like that, where I'm checking on the health of your account. So I'll say, oh, your wife passed away. Did you ever update the beneficiary? Because a lot of times people did put beneficiaries on things years ago, right? And then the person passes away or circumstances change and they never update it. So when they come to me, I always give them the homework of contacting all their financial institutions, double checking that everything is titled the way they think it is. And one other thing I was going to say that people ask me a lot, if you do prepare a will or a trust, or we do any of that, you're not stuck with your choices. At any time, we can always do something called a codicil to the will, which is just basically a change to the will. You can do an amendment to your trust. You can completely revoke your will. We typically do revocable trust, so you can revoke that, and revoke is just, you know, a fancy word for saying I don't want this anymore. I want to change my mind. So none of these things are permanent unless you pass away, then they become permanent.
That's right. So, hey, be nice. Be nice to your family members, because it could change at any given moment. Sure. And then the other thing I wrote down is just be prepared to get financially naked. Like, we're going to have some straightforward conversations with regards to money, assets, things of that nature, and be open to that. So listen, I've enjoyed our time together. I really do believe that the people who watch this are going to enjoy it as well. You're an absolute rock star. It's a privilege to be in proximity to you and to work with you. And I look forward to, you know, continuing to do so. And I look forward to the next time we connect. So if you guys have enjoyed this episode of the podcast, be sure to smash the subscribe button. If you think it would be helpful or useful to people that you know, go ahead and share it with others. And we look forward to connecting on the next episode. So thank you, Danielle, and look forward to talking to you soon.
Thank you.
So if you look up badass or badassery in the vocabulary, you'll probably find Aaron Novello's pictures right next to it. So I got to interview Aaron in the Team GoGo Agent Attraction call a few months back, and I didn't know who he was.